Okay, let's jump right in. Today in this explainer, we are looking at an absolutely wild piece of legal history. We're talking about a case where a simple, unpaid tax bill from a literal poultry farm escalated into a massive constitutional crisis. I mean, it's a story that threatened to completely unravel an entire local government system in South Africa during the late 1990s, which was a super delicate transitional period. We'll be looking at this insane constitutional court standoff between the government and Paarl Poultry Enterprises. It's got it all, you guys. Bureaucratic bungling, incredibly high-stakes litigation, and a brilliant, if honestly slightly terrifying legal strategy coming from a chicken farm, right? Let's get into it. So to understand how we actually arrived at a full-blown constitutional crisis, we have to start right here with this exact number. 320,217 Rand and 75 cents. That is the precise amount in unpaid levies that Paarl Poultry Enterprises, which was trading as Rosendal Poultry Farm at the time, owed the local Winelands District Council. Just for some context, this bill piled up over a period from July 1995 to September 1997. Naturally, the District Council sued the farm to get their money back. Standard stuff, right? But instead of just paying up or, haggling over the math, this chicken farm decided to take a completely different, highly aggressive, and frankly audacious legal route. The poultry farm effectively turned around and asked this exact question. They actually looked super closely at the laws governing the district council and, well, they found a brilliant legal loophole. They didn't argue that the tax itself was unfair. Nope. They argued that the Winelands District Council itself was unlawfully constituted. Think about that. If the government body asking for your money technically shouldn't even exist, well then they have zero legal authority to collect those taxes, right? The farm went to the court and asked for a declaratory order, basically saying the council had been improperly and unlawfully constituted since July 1st, 1997. Therefore, every single decision they made, including the decision to sue the farm for taxes, was completely incompetent and totally invalid. This argument was so profound, it eventually forced the Constitutional Court, South Africa's highest court, to step in and deal with it. I really want to anchor you in the sheer stakes of this right away, because this wasn't just about one poultry farm's tax bill anymore. If the court agreed with Paarl Poultry, it wouldn't just be the Winelands District Council going down in flames, it would literally be 7 district councils across the entire Western Cape. We're talking total systemic dislocation and absolute chaos. Just imagine erasing 18 solid months of government actions. Poof, gone. Every property transfer, every single employee hired, every health regulation passed, and every single rand collected in taxes over a year and a half would instantly become legally void. No way around it. Okay, so let's look at this timeline to figure out how a messy government transition even opened the door for this kind of massive tax dodge. We have to rewind a bit to 1993. South Africa passed the Local Government Transition Act to help guide the country from apartheid-era structures to democratic ones. Now, initially, this act didn't require district councils to use proportional representation. But in November 1996, Parliament amended the act, basically saying, hey, proportional representation needs to kick in by July 1st, 1997. But here is the critical error, the massive blunder. Nobody in the Western Cape provincial government did anything to update the specific local regulations to meet that July deadline. They totally missed it. And it wasn't until way later, in December 1998, that the government finally woke up and acted to try and fix the mess with Proclamation 52. To put this into perspective, think of this whole situation like playing a really complex board game. The ultimate governing body of the game updated the core rulebook to say, okay, from now on you must play using proportional representation. However, the local organizers, the folks who actually set up the board and hand out the pieces, they never printed the new specific instructions. So the local councils just kept operating under the old rules they already knew. You have to remember, the primary structures of rural local government back then were incredibly complex and severely under-resourced, which made the transition way slower than in the big cities. So these district councils just kept going to work, providing services and collecting levies, completely oblivious to the fact that the legal ground beneath their feet had totally shifted. So, when another court case actually highlighted this massive oversight, the provincial member of the Executive Council, or the MEC, started panicking. To stop the impending chaos, the MEC issued a proclamation in December 1998 to finally implement the new proportional representation rules. But, and here's the kicker, they also tried this retroactive rescue mission using a really dense piece of legal jargon called a savings provision. Now, what is that? Well, the MEC effectively wrote a clause saying, yes, we know the councils were technically operating incorrectly for the last 18 months, but we hereby declare everything they did during that time perfectly valid and legal. Basically, a massive legal do-over. Just look at the sheer scope of this retroactive rescue. It is staggering. The government was frantically trying to legitimize every single thing these district councils did for a year and a half. We're talking movable and immovable property transfers, taxes, lawsuits, employee appointments, contracts, permits, the whole shebang. It was this massive, sweeping Band-Aid meant to hold the literal reality of local governance together. But Paarl Poultry, they saw this Band-Aid and they realized it was their golden ticket. They stepped up and argued that the MEC didn't actually have the legal power to retroactively validate a council that was illegally constituted in the first place. And, incredibly, their gamble paid off at first. No joke, the Cape High Court actually sided with the poultry farm. The High Court declared that, yep, the district councils had indeed been improperly elected since that July 1997 deadline because they failed to comply with the new national amendment. And worse, they struck down the MEC's savings provision entirely. They ruled it was ultra-virus, which is just a fancy legal way of saying it was legally beyond the MEC's authority to enact. According to the High Court, the government couldn't just wave a magic wand and retroactively legitimize 18 months of unlawful government. So at this exact moment, all thanks to a local chicken farmer, the Western Cape was staring right into the abyss of total administrative collapse. But wait, here comes the ultimate legal twist, delivered by Judge Yakub at the Constitutional Court. When the government naturally appealed this terrifying decision, the highest court in the land looked at the exact same set of facts, but they reached a completely different, honestly incredibly elegant conclusion. The Cape High Court, as we just saw, thought that councils were illegal, making the savings provision invalid. But the Constitutional Court? They ruled that the councils were actually lawfully constituted all along, making the MEC's panicked savings provision completely unnecessary in the first place. Plot twist! Let me explain how Judge Yakub arrived at this genius conclusion, because it's actually fascinating. The twist is that even though the national government passed an amendment requiring proportional representation, a law can't magically implement itself, right? It required the local MEC to write new, detailed regulations allocating the exact number of seats to specific rural and local councils. The MEC totally failed to do this. But, and here is the crucial legal linchpin, the old rules establishing the councils were never actually repealed. So until new rules were written to replace them, the old rules remain the law of the land. There was zero legal vacuum. The councils weren't illegal at all. They were just operating under the only valid legal framework that currently existed for them. Sure, the MEC was guilty of a massive, embarrassing bureaucratic delay, but that delay didn't automatically render the existing functioning government unlawful. This quote from the judgment, which actually references the Supreme Court of Canada, brilliantly illustrates the core philosophy of the Constitutional Court in this case. Basically, the rule of law isn't just some rigid set of trapdoors designed to catch people out on technicalities. That's not what it's for. It is fundamentally designed to prevent chaos and maintain a functioning society. It's about a, quote, purposive ordering of social relations. The idea is that punishing everyday citizens, or in this extreme case, completely dissolving an entire regional government, just because a provincial official was late in updating a regulatory framework, that goes against the very spirit of the Constitution. The law is meant to build and support a stable society, not tear the whole thing down over a paperwork delay. So the crucial point I really want to leave you with today in this explainer is this. At what point does exploiting a legal loophole become an actual threat to the very structure that holds our society together? Think about it. Paarl Poultry found a genuine, legitimate flaw in the government's timeline, and they tried to use it to wipe out a massive tax debt, risking the stability of literally millions of people in the process. The Constitutional Court had to thread a very, very fine needle here, acknowledging the government's obvious mistake while legally safeguarding the existence of the government itself. It's a wild story, but it really forces us to ask, when government bureaucracy fails, who should really pay the price?